Okay, everybody, we're going to get started. Speakers, you all set?
Yes.
All right. All right, good morning and good afternoon, everybody. This is Tom Hagee. I'm with HB Litigation Conferences. And on behalf of our speakers today, I want to welcome you to this CLE eligible webinar. It's titled Marijuana Insurance, Risks and Legal Quirks in a Developing Industry. I just want to have a couple of administrative announcements before I turn it over to the presenters. If you experience any trouble during the webinar, please contact GoToWebinar's technical support group and their number. Let me just give that to you. You can show it on the screen. It's 800-263-6317. So if you have any trouble with the technical aspects of the webinar, please give them a call. Also note a survey at the end that's going to be available to you so we can get your insights on what kinds of topics you'd like to see us cover in future sessions. And if you're interested in working with HB on webinars or conferences, you can let us know that too. But please let us know those things. We launch a number of our webinars and our conferences based on the feedback from our attendees. Also, a lot of our attendees, looking at them, we have over 300 firms and companies registered for today. Many of you have expertise in your own right, so if you have questions, please share those in the questions section of your control panel and click send. We can't accept verbal questions, so you have to do them by that text feature. So make sure you type those in there and hit send. We'll get to as many as we can. For those that we can't get to, we'll try to answer them after the webinar. Also, you're going to see a slide deck, which you can't immediately download, but we'll make sure you get that at the end of the seminar too. So you will get what is considered the handout for today, which is this PowerPoint presentation. Again, this is CLE eligible. There are going to be 2 CLE codes that I'll announce during the webinar. Make sure you write those down, please. You'll receive the necessary form. We're going to send that to you by email after the program, so you'll want to make sure you have those codes entered on the form and follow the directions that we send you. We want to make sure you get credit for attending today. So with that, we're thrilled to have two speakers with us today with deep expertise in this area. First is Hillary Bricken. She's with Harris Moray, the law firm. Hillary, I won't read her whole bio, but you can see that she focuses on advising startups, entrepreneurs, and other businesses through various aspects of their development. You can see that these and other publications listed have consider Hillary a rising star in this field. She also writes a column for Above the Law, which is, I think everybody's familiar with that widely read blog. So it's great that she does that. And I also noted here, I like when people put in something personal about themselves. She's got a very large dog, a Cane Corso Mastiff. I did look it up. It's a large dog. For those of you who are curious, it looks like that. I don't know if that's her dog or not. Just to give you the dimensions of it, wanted to help you out there. So thanks to Hillary for joining us today. Also with Hillary is Robert McKay, also with Harris Moray, and Robert advises clients in the regulated substances area. He also works with entrepreneurs and developing organizations. He advises them as well on cross-border transactions. And Robert he practiced in international law at a law firm in D.C. You can see he also was with other organizations in D.C. He didn't list the breed of his dog, but I found out through some discussion that it's a Corgi, for those of you dog lovers out there. So with that, I'm going to turn it over to Robert and Hillary to give you the substantive part of this presentation. I'll interrupt later again with the CLE codes, and please take advantage of the question feature on the webinar. So I'll turn it over to the speakers.
Thank you, Tom, and thanks everyone for joining us. So we've got this question box in front of us. So if you ask questions during the presentation, and it's easy for us, we'll try to step in and answer those during, and we'll also leave a little bit of time near the end for questions. Hillary and I have been involved in the cannabis business practice for quite a while. She's been doing it since probably late 2010. I got involved at the tail end of 2011, and so we've seen it go from a really quasi-legal grayish market industry here in Washington, where we're based out of, to being something that it's really starting to become sophisticated. So today we're going to talk about a bunch of different issues, as many as we can fit into the hour, with regard to how cannabis, fits into these number of categories and topics that touch on insurance. So we're going to talk a little bit about sort of federal law and enforcement and the conflict between federal and state law. We'll talk contract enforceability, touch on banking and real property issues, and we'll close it up with some talk about products liability before we go into questions. And so to start us off on federal law, Hillary will get rolling.
Thanks, Howard. Okay, so good morning, good afternoon. My name is Hillary Bricken. I am licensed to practice in Washington, Florida, and California. And what may surprise some of you listeners out there is that all of those states have some form of medical marijuana law or even adult use marijuana law on the books at this point. And I like to mention those 3 states because it really gives us a good spectrum of what's going on in the United States as a whole when we talk about state-to-state marijuana policies in the context of federal prohibition. With Florida, they have a very minimal medical marijuana program. Only 5 nurseries in the entire state that have been in existence for 30 years are allowed to cultivate and distribute the product. The program is not even off the ground yet, as compared to California, which has had medical marijuana since 1996 and has a very well-entrenched, robust medical marijuana economy that is not regulated. There is little to no state oversight regarding that industry, and that's posed huge problems for California regarding federal enforcement. Now, if you look at Washington, Washington is a very special hybrid marketplace. Like California, we've had medical marijuana since 1998, and for more than a decade, our medical program was extremely unregulated. Nobody wanted to touch it because of the threat of federal intervention. But then in 2012, when we legalized for adult use, beginning in 2013, that is when we began to see a highly regulated recreational adult use market, and medical has slowly followed suit, and by this summer, both industries will be regulated by our Liquor and Cannabis Board, really representing, I think for the first time ever, 2 programs, medical and recreational, under the same regulatory umbrella that are robustly regulated by a single agency. It's a pretty big deal as far as where this is all going in the future. Nonetheless, all 3 of those states have the same problem when it comes to federal law, regardless of the fact that those 3 and 20 other states and D.C. have some form of legalized or decriminalized marijuana for medical or adult use. The Federal Controlled Substances Act is still alive and well. And for better or worse, it still lists cannabis as a Schedule I controlled substance. Now, if you don't know your schedules, no big deal. The only thing you need to know about Schedule I is that it's reserved for the worst, most dangerous drugs in the United States. And a Schedule I drug, really what it means is, and it's defined under federal law, as having a high potential for abuse, no currently accepted medical use in treatment in the U.S., and there's a lack of accepted safety for its use, even if it is under medical supervision. And just so you know, marijuana makes its home next to LSD and heroin on Schedule I. But what it means for business folks on the day-to-day, and for state regulators, and for insurance companies that support in the ancillary sector, is that it is a federal crime to possess, cultivate, manufacture, or distribute cannabis. So every day in all of these states, the moment these business owners put hands on the inventory, they are in clear violation of federal law. And Tom, if you could you go to the next slide, please? Okay. So how have the feds dealt with this particular issue? It's not the first time in U.S. history that we've had a state versus federal conflict. It may be the most recent one, but it is certainly not the first. Nonetheless, the feds have opted to handle it kind of in a very strange way when we talk about policy. And the way this manifests typically is in enforcement, usually in the form of indictments and forfeiture and seizure. But the feds in recent years have kind of taken their foot off the gas pedal when it comes to enforcement of marijuana laws in states that have robust marijuana regulation. But let's start from the beginning. And if any of you haven't seen these enforcement memos from the Department of Justice, if you're going to represent an ancillary company, like a landlord or an insurance company, or you're going to represent a cannabis business, you'd be doing a great disservice to your client if you didn't have the history of what these memos stand for in your back pocket and ready to discuss. And I'll put it like this. to kind of give you the short version, essentially since 2009, the feds and the states have really done a dance with each other over legalized marijuana. In my opinion, the states have really gotten out in front of this issue, and frankly, they're leading the way where Congress is not ready yet to deschedule or decriminalize cannabis, and it's highly unlikely that President Obama will reschedule or deschedule it, departing his presidency in his second term. Nonetheless, the states continue to opt out of prohibition for one reason or another. However, in 2009, the first enforcement memorandum issued from the Department of Justice. And the important things about these memos are to recall really two things. Number one, they are for U.S. attorneys by U.S. attorneys. They are not meant for public consumption, and they are certainly not anything that you could use in court, for example, to mount your defense against federal prosecution. Number two, hinging off of number one, these are not law. They are not binding. They can change at any given moment, and they can change under any given president. So you can imagine the entire industry is kind of sitting on pins and needles waiting to see who's going to get the presidency in 2016, because the world is going to look very different if Bernie Sanders gets the presidency versus Ted Cruz. Nonetheless, the first memo issues in 2009 by then Deputy U.S. Attorney General David Ogden. And what this memo had to say essentially was that we as the federal government understand that states have opted out of federal prohibition in favor of medical cannabis. And at this point, we didn't have any recreational use. It was strict, straight-up medical marijuana, California being the first in '96, so we've had it for a while. This represents the feds' first actual formal response to that particular conflict. And what the memo had to say was, as long as you are in clear and unambiguous compliance with state laws, you become less of an enforcement priority for us, because we neither have the resources nor the manpower to pursue everyone. However, if you are not in compliance with your state laws, you will get on our radar and we will act accordingly. And in fine print towards the bottom of the memo, the feds do us the service of reminding us, regardless of what this memo contains, it is still and always will be until the law changes a federal crime to manufacture, cultivate, possess, and distribute cannabis, even for medical use. So we get the Ogden memo, and the way the industry kind of accepted that and digested it was that it was a green light from the federal government, that because of a lack of resources and real oversight from state to state, the feds were going to let medical marijuana slide. And as a result, between 2009 and 2011, we saw a huge proliferation and expansion of medical marijuana businesses, mostly unregulated, really expand throughout the western corridor of the United States, really starting with Washington, Oregon, California, and moving east. As a result, in June 2011, we get another enforcement memorandum then from James Cole, then acting U.S. Deputy Attorney General. Now, what Cole has to say is, dear U.S. attorneys, when you are looking at how to enforce federal law in states with marijuana laws, remember the Ogden memo? Well, we're not exactly going to retract it, but we want to expand upon it. And our new opinion is that even if you are in unambiguous and clear compliance with state laws, we do not care. You are still an enforcement priority, you are still violating federal law, and we will pursue everybody in the chain of distribution and in the licensing chain accordingly, including state employees, including landlords, and any ancillary businesses that support these illegal entities. It was a massive retraction by the federal government, regardless of how Attorney General Cole felt about the Ogden memo. It was a clear sign that the federal government was alive and well, and that they were not interested in allowing the democratic experiments to move forward in the way they had, where inevitably what we had was a bunch of unregulated, very large-scale grows with a ton of diversion into states where it was illegal, and even international drug trafficking. So the federal government acted accordingly, and after the Cole memo in 2011, we saw a large number of raids, increased indictments, and criminal prosecutions across states with medical marijuana laws. Now let's fast forward again. Let's fast forward to November 2012. What happens? Colorado and Washington legalized marijuana for adults 21 and up to an ounce for the first time in history, really the history of the world, certainly the history of the United States. Now, this is a huge regulatory undertaking in these states who are not getting any help from the feds, both financially and policy-wise, and well into the rulemaking in both states. August 29, 2013, we get another memo from U.S. Deputy Attorney James Cole. Many people were very worried about what this memo would say, given this huge huge shift and change when it comes to marijuana and state opt-out. Now, that memo said two things, surprisingly. The first was the federal government will not expend resources to pursue a legal action against either Washington or Colorado in federal court to strike down the law based on preemption or supremacy. They were not interested in that. The second and probably more important point behind Cole Memo 2, that's how we have it identified in the slide, is that the feds finally and formally acquiesce really to robust regulation under state law. That's key. If a state does not have robust regulations, the federal government is going to make them a priority. And really in Cole Memo 2, what we also see are the 8 enforcement priorities outlined by the federal government for the first time ever, formally and finally, how they will prioritize, who they will pursue. Now that we have guidelines to move forward under Cole Memo 2, we have not seen a single prosecution, at least in Washington state, of a robustly regulated licensed marijuana business. The feds have actually kept their word, is my point. It still does not change the fact that the bottom line is that marijuana is still illegal under federal law, whether medical or recreational, and even under a robust regime with a new attorney general and a new president, things can change instantly because we do not have a change to the Controlled Substances Act. Now, Loretta Lynch, she is the current acting attorney general. She is the successor to Eric Holder, and so far she has said she will honor the second Cole Memo. She's also said that in her personal experience, she cannot say that marijuana is less dangerous than alcohol and is certainly not paying attention to the science, but she has said as acting attorney general, she will abide by that memo. Now, another memo issued in 2014, really later in the year, that's not on this particular slide because frankly it's a little tangential to this particular topic, but the tribes, U.S. Indian tribes, were also making inquiries to the Bureau of Indian Affairs and to the Department of Justice, really twofold. Number one, will you be there to enforce federal law on tribal lands if we don't want pot coming into our jurisdiction? And number two, how do we get a piece of the business? How do we get a piece of the action? How can we participate? And the resulting memo is called the Wilkinson Statement. Monty Wilkinson is a U.S. Attorney General, and he authored a memo basically saying if tribes want to legalize cannabis for medical or recreational use as they see fit on tribal lands, they will be allowed to do so if it's done in concert with the U.S. Attorney in their jurisdiction and if it adheres to the 8 enforcement priorities stemming in the Cole Memo. So far in the state of Washington, we've had 3 tribes, the Squaxin, Suquamish, and Puyallup, that have inked a compact with the state to participate in our legal regime. Outside of that, the tribes that have attempted to cultivate or process or distribute cannabis in other states have not fared so well with the federal government, probably because in those states there's not enough regulation to sustain those projects. And I know today's topic, obviously, about insurance, and we are going to get there, but you have to understand the background coming from the feds and the conflict that's in play here in order to advise any client that's in the industry, including insurance companies that are looking to provide insurance.
Sure. So we've got a couple of questions that play into, I think, the same. So one of these is, what are the risks for incorporating these corporations for clients, right? And so let's say this is for attorneys, what are the risks to attorneys? And the other question was from an insurance broker, what is the risk of putting together an insurance program for recreational cannabis shops? So this is something that everyone in the ancillary services field to marijuana businesses, including Hillary and I, and including you that are providing insurance to businesses, needs to deal with. And it's something that banks have to deal with, and it's something that anyone who provides services to pot businesses has to at least think about, which is under the Controlled Substances Act, first, are people in our position aiding, let's put aside the memos for a second. Are we aiding and abetting in the violations of criminal law, right? Are we aiding and abetting of the distribution, manufacture, possession, processing, use, etc. of marijuana? And the answer to that is maybe, right? Maybe. We're not criminal attorneys here, but it all comes down to intent when you're talking about accessory liability. Do we have the requisite mens rea, it's called in criminal law, do we have the requisite mental state in order to be found guilty of that sort of a criminal violation? It's complicated. we know that our clients are engaging in these sorts of actions, but we don't necessarily intend that our clients or our customers engage in these actions, right? Our intent is to incorporate a business and finance a business or provide an insurance package to a client. So it's a complicated question, but criminal law doesn't end there. We also have to look at U.S. money laundering laws, and it's something that we deal with on behalf of our banking clients all the time. So you have two criminal money laundering laws that we're looking at. One's 18 U.S.C. 1956, and the other is 18 U.S.C. 1957. So what Section 1956 says is anyone who accepts funds where they know that the funds are proceeds of specified unlawful activity, which basically means you're accepting money from someone that you knew came from what the feds are considering a drug deal, then you are potentially guilty of violating money laundering law if you intended to conceal the source of the transaction, or you intended to assist with so you intended to promote the transaction, or you intended to promote the illegal activity, or you intended to violate federal law in any way. But Section 1957, the next part of the money laundering statute, makes it even more complicated, where Section 1957 gets specifically into there is no intent requirement. If you're accepting money over $10,000 and you know that the source of that money was based on somebody's marijuana sales, then you're guilty of that money laundering violation. So what does that mean for attorneys and insurance brokers and anybody else who is involved in this space? Well, it means that we, much like those that are in the cannabis industry, are somewhat reliant on the federal enforcement memoranda. And that's why attorneys, insurers, banks, etc., need to be keenly aware of what states are highly regulated and what states are not. California, as it currently stands, probably does not fit into that highly regulated space. It's getting there, right? They passed a new medical law recently. They're likely going to legalize in 2016 recreationally. But the old California market, where you had these collectives, these semi-gray market businesses that weren't completely clearly allowed under state law, probably don't fit into what the federal government was saying was getting to with these enforcement memoranda.
We have another question that's relevant to this particular topic of federal policy and enforcement. Congress did last year renew and the year before passed a section in the appropriations bill called Section 538, and essentially what it did was it mandated that the Department of Justice could no longer expend funds, and that Congress would not support that allocation to interfere with states that are implementing specifically medical marijuana laws. The language beyond that is not more robust than that, and the backers of the bills essentially said that their intent was that what that would mean would be that the Department of Justice would no longer waste time raiding state law compliant facilities. The Department of Justice had a very different take, and they even have a very lengthy memo on how to defeat a Section 538 criminal defense, that you shouldn't prosecute me because I am in compliance with medical marijuana laws, and Section 538 says you can't spend money on prosecuting me as a criminal. A case has come out of California, basically, where the judge, the federal judge, agreed that that particular section of the omnibus prevents the Department of Justice from infiltrating and really punishing those that are in ostensible compliance with medical marijuana laws in their state. However, that case is now currently on appeal by the Department of Justice in the Ninth Circuit. Our personal opinion is that it's highly unlikely that the Ninth Circuit is going to agree with the federal judge on this particular issue, mainly because that Section 538 defense has been used multiple times prior to this case, and it has failed, despite the intent of the bill's backers. So we look at Section 538. We're not quite sure that it actually harmonizes any of the enforcement memos. While you could certainly use it as a defense, for example, in a criminal case, certainly different federal judges have had different opinions on its effect and intent.
Sure. Okay, so we'll get back on track with the slides. So Tom, can you go back to the contract enforceability slides? I'll
Sure. Yeah. Let me just
Uh,
interrupt with the. Let me give the CLE code to Robert. Sorry to interrupt you. The first
sure.
CLE code for everybody, if you could please mark this down. It is 4022. The first CLE code is 4022. It's great to see also so many questions coming in, so please take advantage of that. Thanks, Robert. Make sure I'm on the right slide.
Uh, sure, this looks good. I had a couple. Basically, we're going to get into contract enforceability. Okay, so you're an insurer. You're signing a contract where you're saving a premium, and if XYZ takes place, then you, the insurer, have to pay the insured X many dollars. Great. Is that contract actually something that a federal court is going to enforce if one of the two of you decides to litigate on the matter, which, sad to say, is not uncommon in the insurance industry? Well, standard contract law tells us that courts do not enforce contracts for illegal purposes. But here we have an interesting quandary where the purpose is likely considered illegal under state law, under federal law, but is considered legal under state law. And there is no answer for you other than to say that no state has settled law right now on whether contracts involving marijuana businesses are strictly enforceable. So I've got a couple of examples here. In Colorado, you had two different cases in different district courts in 2012. They came out on opposite sides of the issue. The first case, there was a simple contract to sell medical marijuana within Colorado's regulated medical marijuana dispensary program. And the court in Arapahoe County threw it out, said it was void as against public policy. Later that year, you had another relatively simple contract. This is where someone was going to be employed by the business, and he bought a bunch of equipment, and the company was supposed to reimburse him and didn't. He sued them, and that court found that the contract was enforceable. Let's look at another state, California, which didn't have as well of a regulated system as Colorado. In California, one of the most famous dispensaries in the entire world, it's called Harborside Health Center, and they were based out of Oakland, I think, and they were making, say, like $25 million a year at their peak. They were doing huge numbers, and the attorney general, or the U.S. attorney in California, her name was Melinda Haig, decided to try to make an example of them. And so she actually sent a seizure notice to Harborside's landlord that said, we're going to seize this building because your tenant is violating federal law, and we have the right to forfeiture of the property. The landlord, not wanting to lose the building, tried to evict Harborside, and Harborside took that case to court. And Tom, this is on the other slide, sort of just shows this. Harborside took this, it's the first one, it's Cratian versus Patients Mutual Assistance Collect Court. Harborside took it to court, and they stated, we have a lease with this landlord. The lease says that we're a marijuana business. They can't evict simply because they want to. And the court ruled in favor of Harborside, and the court said, we understand that this is a violation of federal law, but this is a state court, and we're enforcing the laws of the state of California, and under the laws of the state of California, Harborside isn't, according to us, breaking any law, so we're going to enforce the lease. Follow-on to that is, I think Harborside is still, that was a 2012 case, Harborside is still open in the same location today, so they've been pretty successful there. The other case that I show here was a case in the following year, in 2013 in California. Again, it was a contract to invest in medical marijuana grow, and the court in Sacramento found it unenforceable due to federal illegality. So what does that mean? When you are drafting an insurance contract, you may not know, even if you're doing it today, depending on what state you do it in, you're not going to have a really positive outlook on its enforceability. Now, we think that as of today, state courts in Washington, Colorado, Oregon are likely to enforce marijuana contracts. But we can't say that for sure, and a lot depends on where you go, and a lot's going to depend on when these types of contract cases finally make it up to state courts of appeals and state supreme courts, so that we can actually get some binding law on this. But if you're interested in actually having your contracts enforced, one alternative is to go to binding arbitration. And the reason is we've generally found that arbitrators are much more likely to find enforceability on these sorts of contracts for the reasonable purpose of knowing that arbitrators like to get work, and they're more likely to get work if these sorts of contracts are enforceable. And in fact, there's some arbitrators that are holding themselves out these days as specific cannabis arbitrators. So it's something worth looking into.
And just to chime in, somebody asked, what is the name of that case regarding Section 538 with the feds? It is U.S. versus Marin Alliance for Medical Marijuana, and that's MAMM. And the first filing was initiated in 1998, for whomever is interested.
Sure.
Do you have any other questions on contract enforceability?
No, there's a couple of questions. A lot of the questions we're getting are from attorneys, or things like, how do national law firms deal with this? How do you handle cash retainers? Are there some specific issues there? And it's something that we've been struggling with for a while. Our primary concern is first to make sure that any client that we represent is in a state where marijuana is highly regulated. If the client is not in a state where you have those types of regulations, we don't feel like we can do anything to protect the client, and we feel like we're exposing ourselves to too much risk. But as long as we're licensed to do work in the state, and the state has the robust regulations that we're looking for, that's the risk that we're willing to take, and that's sort of the risk that I think each of you, if you're going to be looking in this space, have to get into. But early on, this industry was very interesting for us. Like I mentioned at the start, it has gotten more sophisticated lately. We're not getting huge cash payments as much as we were. Banking is a little bit more accessible now than it was 3 or 4 years ago. That said, there was a time when we were getting $5,000, $7,500 type retainers or payments that we had to take to our bank account, and sometimes that money is if it's sitting in a nasty recreational pot shop, it stinks like marijuana, and it's that's something that you have to explain to your bank, and it's something that thankfully the industry is starting to get away from.
And for what it's worth, the bar never took issue with us taking cash payments from the industry. And if you are an attorney and you're worried about the ethical issues associated with the industry, it's going to be different from state to state. Some states are very relaxed about it and have basically added comments to their essential RPC 1.7 saying, we will not, just by virtue of practice in the area, go after a lawyer for unethical conduct. We do not consider this to be the support of a criminal enterprise when the lawyer simply is providing guidance on what state law is. But let's say the lawyer takes a business interest in the cannabis business, or is somehow facilitating large cash transactions through their trust account from a criminal source. That's going to be different, I think, from bar to bar. And really, the line for most states has been assist versus advise. States are fine with advise, but the way that they define it is going to vary from state to state, and assistance in most states is going to be where you toe the line on unethical conduct, for what it's worth. Do you want to move to banking?
Yeah. So
okay.
So the next risk area we're going to get into is banking. And I talked about this slide somewhat, but in this context, we're talking about banking. We're talking about access to banking for marijuana businesses, and that also varies state to state. And so in this slide, where we're talking about access problem number 1, federal criminal law, those are the same exact issues that attorneys and insurers and anyone else who's receiving payments from marijuana businesses need to deal with. In general, what we've seen is large banks don't feel comfortable getting into the marijuana business, even given the various enforcement memoranda that have gone out. And one memo that Hillary didn't touch on was the Cole memorandum from February of 2014 that went out at the same time as a Department of Treasury memorandum from an entity there called FinCEN. And so what the 2014 Cole memo said is, as long as you're in a state that's highly regulated and you meet all of these other 8 enforcement priorities that we have, we're also not intending to prosecute violations of these money laundering statutes, right? 18 U.S.C. 1956 and 1957. At the same time, and this is directed at financial institutions because I think the Attorney General at the time saw that lack of access to banking was really a hindrance to the industry, and it was creating some real risks. So if you have a bunch of cash on site, It's hard to pay your employees. It's hard to pay your taxes. You're more likely to be involved in risky activity, theft, etc. At the same time, FinCEN's Financial Crimes Enforcement Network put out its own memorandum that said, okay, for dealing with civil anti-money laundering law under the Bank Secrecy Act, here's the type of due diligence that you, a bank, need to go through in order to properly, under our rules, bank marijuana businesses. They need to file these constant suspicious activity reports on behalf of marijuana businesses. And what we've seen in the wake of those two memoranda is that small banks and credit unions and those types of institutions that are willing to take on some risk in order to get a little bit more business are more likely to provide services in this industry. But even not a lot of those. In Washington State, we probably have 5 or 6 financial institutions that are currently doing this. In Colorado, they probably have about the same number. In Oregon, which is really just getting started on legalization, they have about 1 that's really openly involved in the cannabis industry. And so if you're in this space, you're very likely going to be, if not working with businesses that don't have bank accounts, at least exposed to. Businesses that don't have bank accounts are going to want to try to work with you, and that's where we get back to the all-cash nature of this enterprise, which, along with all these other risks that we're talking about, actually it means that the business itself, the marijuana business, may have a different risk profile, and the types of policies that insurer writes may be based on the fact that it also needs to write policies knowing that a cannabis business is going to have a bunch of cash. Let's go to the next slide or two. This is another reason that you don't see a bunch of banking out there. And given where we are, I think we can move on to a couple more questions. Okay, so we've got one question. Would Maryland meet the qualification of a highly regulated state? And the answer there is yes. Generally, what you see in highly regulated states is what you saw in a state like Maryland, where they put out licensing for marijuana businesses, and in that licensing process, they ask for criminal background information on all the business owners, officers, directors. They ask for financial background information on the owners, officers, directors. They mandate that the business follow certain security procedures, certain operating procedures. Those are the sort of things that you're looking at with regard to regulation in what the federal government is going to refer to as a robustly regulated state. Okay, so that's the final thing I was going to talk about was a Fourth Corner Credit Union, because it's a case that just came out of the courts of Colorado. It's a federal court case where Fourth Corner Credit Union is a new credit union, and it was chartered by the state of Colorado, and it applied to the NCUA, that's the National Credit Union Administration, and the Federal Reserve to get some state or some federally regulated things. So you apply to the NCUA to get deposit insurance. You apply to the Federal Reserve to get a master account, which lets you get access to the ACH system, the online payment system, etc. So the NCUA and the Federal Reserve, after taking several months, both denied Fourth Corner Credit Union. Fourth Corner sued, and it lost. And there was a bit of a talk afterward, like, what does this mean for banking in the marijuana space? And I think it means a few things. First, the reason that the NCUA denied Fourth Corner, it wasn't specifically because they were doing marijuana, or at least it wasn't solely because they were involved in the marijuana business. It was really because Fourth Corner hadn't put forward a business plan that included a bunch of different industries it was going to bank, or an exit plan from the marijuana space, because the NCUA really is an insurance agency, much like a lot of you that are on the call right now. And what the NCUA wanted to see is they didn't want to see overexposure in one of their insured credit unions to the risks of what is a very new industry, and an industry that the federal government could shut down at any time. There's other credit unions that have gone through NCUA scoring after they've openly provided services to marijuana businesses and have come through clean. And what all those credit unions have in common is that they offer services to a wide variety of industries. They don't have any type of really concentrated interest in the cannabis space. It's just one of many businesses that they do work with. The Federal Reserve, that's a tougher one, where I have a hard time seeing the Federal Reserve giving a master account to any new chartered institution that is doing work in the cannabis space. At the same time, if you're an existing institution with an existing Federal Reserve master account, I also have a tough time seeing the Federal Reserve really taking the time to go in and try to cancel that account. So it's a lot like the standard. It's better to ask for forgiveness than beg for permission situation, where existing institutions that already have those accounts are in a much better position to continue offering services. Okay, moving on. We've got just one quick slide that talks about some of the issues that we see in real property. Cannabis is interesting. It's a lot like agriculture, and it depends on what state that you're in. In Washington, we have an allowance for outdoor cannabis growing, for indoor cannabis growing, and for greenhouses, really for everything in between. And so each property is going to have a slightly different risk profile. Some of these other states, Nevada, for instance, it's only allowed as an indoor grow operation. And so when you have indoor warehouse grow operations, you're facing a few different risks than you face maybe with other commercial activities. But you're dealing with an environment that has a lot of moisture. It's got a lot of lights. It's got a lot of electricity pumping through it, and it potentially has a lot of cash on site, right? And cash, along with marijuana itself, are both very valuable and very mobile targets for theft. And so I think all of these items offer at least some added risk that need to be taken into account. An example, Lloyd's doesn't do, I don't think Lloyd's does insurance policies for cannabis property anymore, but they did. And one of the things that Lloyd's underwriters made sure to put into place for any, let's say, a cannabis retail operation that was going to have cash on site, is they had a double safe requirement, and they had a requirement on the size of the safes. So they wanted all of the cash to be held in a different safe than the marijuana was held in, and they had a requirement that if your safe was under 2,000 pounds, then it had to be bolted down, right? And this was a specific cannabis requirement that Lloyd's wrote into these policies.
Yeah, and I think we should mention that it's becoming common practice in states with robust regulation as part of eligibility to obtain oftentimes an exclusive license to operate a cannabis business in a given state, that a general liability insurance policy is required, and typically in the amount of no less than $1 million. Here in Washington, that is an absolute requirement. Now the question becomes, over and above that, when you're dealing with a landlord that demands fire insurance and other types of insurances in the leasehold, is an underwriter, an insurance company, or a broker going to go there when at the end of the day this is considered federal contraband, and a lot of the activity on behalf of the insured is going to constitute intentional criminal conduct rather than, let's say, negligence. Typically when we've seen these insurance policies, and especially the ones that are identified as 420 insurance policies, whatever that means, and I'm kind of rolling my eyes when I say that, obviously the devil's in the details, and it would not, for me, be beyond reason, for example, for an insurer to go back and say, well, we may have underwritten you for general liability, but we're not going to, for example, cover your crop or your loss of cash because this is all derived and or used for federal criminal activity. And I think what we're going to see in coming years is probably claims from insureds based on bad faith. It's only a matter of time. And I'm sure that some of these state courts, based on Robert's earlier slide regarding contract enforceability, are going to determine really the duty of these insurers to these cannabis businesses in the context of federal conflict. And I also would not be surprised if some of these state courts uphold, for example, the duty to defend, the duty to reimburse, the duty to provide coverage as listed in the insurance contract instead of trying to get out of it because it's illegal and contrary to public policy. Anything else?
No, because we've got about 15 minutes left, and we've got a bunch of slides on products liability. So we'll get into those and then try to answer as many more questions as we can.
Okay, so I'm going to cover products liability because this is a super hot emerging area, and we say that because there have already been tons of recalls out of Colorado, and it's not going to be the last time that the state or an independent actor decides to engage in a recall because these products are defective and or are currently hurting people. It's another emerging area where, in my personal opinion, the courts are really going to decide where the duties lie here. And certainly through the history of products liability cases, we've seen juries really like to punish corporate defendants that either on purpose or negligently put a defective product into the stream of commerce. And with marijuana, the big issue is probably going to be quality assurance testing, ensuring that we're not working with tainted or defective product, and faulty labeling. And it's interesting because in most industries, faulty labeling is not a huge impediment. And a lot of the products liability case law that already exists does not necessarily surround faulty product labeling. The bigger areas by far are negligence, strict liability, breach of warranty, state consumer protection acts. And I've got those obviously on this slide in front of you. Tom, can we advance the slide, please? Thanks. Okay, so basically in those first three areas, negligence, strict liability, and breach of warranty, we've got three theories of law and really three theories of the case. And the first one, at least in negligence and strict liability, is going to be a manufacturing defect, which unequivocally is shoddy workmanship. How is it put together? I do not think that we're going to see this one come into play with cannabis other than, for example, vapor pens and the types of vehicles for use with marijuana, of which there are many. The other day, just in Canada, a teenager was severely harmed by an exploding vapor pen, lost some teeth, had third-degree burns on his face. That I could see manufacturing defects coming in as consumers increase their use with vapor pens. Then there's design defects. Essentially, the product design is inherently dangerous, meaning that it fails to satisfy consumer expectations, and the risks of the product outweigh its benefits. Again, I don't see design defects coming into play here. This is an agricultural product unless and until maybe we see GMO cannabis or some other type of really exotically designed product, and the marketplace, frankly, is not there yet. I don't think that we're going to see design defects. But the last one is the big one as of now, and that would be failure to warn, which commonly takes the shape and form of faulty labeling. And this occurs when the product has inherent non-obvious dangers that could be mitigated through adequate warnings to users. And I don't know how many of you out there have read it. If you haven't, you should. There's a New York Times column by Maureen Dowd, who at the beginning of legalization in Colorado went to Denver and frankly, tripped out and lost her mind on a chocolate bar that was infused with cannabis. And even though it was adequately labeled, she completely ignored the labeling and basically ate the entire chocolate bar and was uncomfortably high in her hotel room for 8 to 12 hours. And that right there, failure to warn, if you're dealing with an eggshell skull plaintiff, or frankly just a first-time user, and they get too stoned and they end up going out, engaging in an accident, or whatever the conduct may be, that's going to make its home in failure to warn. And certainly with some of these edibles, there could be inherent non-obvious dangers that could be mitigated through adequate warnings to the users. Right now, the states are setting the floor on labeling and manufacturing and design of product, but that is just the floor. That's why I really believe that these courts, when they get into these disputes between consumers and those in the chain of distribution, are going to determine where the real duties lie and what is sufficient, for example, when we talk about an adequate warning label. These states cannot do it all by themselves, and they are regulating a ton of areas when we talk about cannabis, and many of them don't even have the budget to do a real consumer safety analysis where they ensure that all of these benchmarks are hit regarding consumer safety. And that's why I think the courts are going to step in and probably take control once we see some filings. And by the way, there's already been one filing in Colorado for a breach of warranty claim. Essentially, a grower's entire crop was recalled because they were using a pesticide that was not necessarily barred on Colorado's pesticide list, and that was called Eagle 20. When Eagle 20 is burned, it gives off hydrogen cyanide. So you can imagine over months, maybe even days of use, there's probably going to be some illness or injury. With the plaintiffs that filed the suit, because they had not yet manifested any physical injuries, they had to file under breach of warranty. And essentially what the cause of action was, we should not have paid this much for this defective, potentially extremely dangerous product, and we want our money back. And they had to do that essentially because they couldn't prove any other physical damages. So these cases are beginning to crop up. In my personal opinion, again, it's only a matter of time, for example, before the FTC gets involved regarding advertising, false claims, sufficiency and safety of products. We know that as a federal agency, just like the NLRB and some of these other agencies that are very consumer / employee friendly, they are just waiting in the wings, even though federal prohibition is still in effect. That would not stop them necessarily from going after one of these companies for any of these issues I just mentioned. So can we advance the slide, Tom? Okay. So I'd be remiss if I didn't mention strict liability, because this is what's going to bite a lot of people despite their best efforts. Obviously, strict liability has nothing to do with the manufacturer's actions or intent. It's liability for the product itself. Super, super aggressive body of law. Essentially, the manufacturer is liable if the product is defective, whether or not the manufacturer is negligent in making the product. Why? Why has the standard come to fruition in the United States? It has nothing to do, obviously, with cannabis or any other product. It's because public policy concerns rose over time regarding below-grade self-set industry standards. And that right now encapsulates the majority of the cannabis industry. Without robust regulation, these guys and gals are calling the shots themselves when it comes to best practices and product standards and consumer safety, which inevitably is going to have some shortcomings. So obviously, for insurance purposes, everybody knows strict liability extends to all parties in the chain of distribution. And when drafting an insurance policy, I think insurers should be really careful about whom they're deciding to insure. You want to go with a party, again, that's in a state with robust regulation that, frankly, has a recall body of law within its own regulations that can guide and keep in check the business so that you don't have to do it yourself as the insurer or worry about rejecting a claim because a cannabis company wasn't careful enough with its products. Next slide. Okay, so really quickly here, marijuana products liability and faulty labeling. This to me is going to be a really big area of development, especially for insurers and insureds. Like I said, the state typically sets the floor for warning labels, but it may not be the standard for safety. The legal standard that we've seen in the courts that's emerged, it's a duty to warn of any danger from intended or unintended, reasonably foreseeable uses of the product. These are dangers that manufacturers actually or should know about. It's a pretty broad standard. Now, warning labels, they can mitigate a lot, but they have to be adequate. And adequacy, as defined by the courts in multiple states over time, it's a highly subjective, fact-intensive analysis by the courts, so the facts are going to matter. A hairbrush case is not going to be treated the same as an axe case or as a cannabis case. But the main standard that's evolved in the courts, and cannabis will not be exempt, is what a reasonably prudent manufacturer would provide on a label under similar circumstances. And as an insurance company, that's going to be really hard to determine when states continue to change their regulations and they don't cover everything in their regulation regarding that particular standard. Just something to keep in mind. Now, the opinion of most courts about what counts as an adequate warning label, number one, the form of a label catches the attention of the reasonable person. So when you're thinking of your reasonable person cannabis consumer, I suggest to you all at least a person of average intelligence, and just assume that they've never used marijuana before. That's the safest standard of all. The content of the label is comprehensible to the average person, so don't use a foreign language. Don't use big words, especially when talking about edibles. Make it super clear what this person is consuming. Also, the label conveys a fair indication of the nature and the extent of the danger of the product. So examples are listed below on this slide. Side effect warnings, safe handling warnings, allergen warnings, unique aspects of the product that could pose dangers. Drug interactions with cannabis and other drugs is a huge area. And that is something that if you're insuring a cannabis business that's a manufacturer or even a retailer, you're going to want to make sure that they've got these standards in check regarding these particular side effects and any type of safe handling instructions, etc. And again, state law is the base point, but it may not be the final say as far as duty between consumer and cannabis business. Next slide, please. Okay, so here's the bottom line with marijuana and products liability insurance. It's an emerging area, guys, and no major case filings really have settled anything yet. We're in the beginning stages of developing the body of law that inevitably will be standards for cannabis and products liability. Obviously, mandating the establishment of sound operating procedures is going to help curb claims. And as a result, insurers need to make sure that an insured maintains these standards. And how you perform that due diligence, how you keep checks and balances on that business, that's where the work is going to come in, because these states are rulemaking by the seat of their pants without any help from the FDA, and really it's going to be best practices in accordance with state law. Following all applicable regulatory laws is going to help curb claims. And again, insurers, your end is going to be due diligence into how these guys and gals are complying with this ever-changing body of regulatory law from state to state. My personal opinion, court cases are going to help develop these operational standards and marketplace safety criteria. So it's certainly a risk to insure and underwrite products liability with these guys at this point, because it's such an undeveloped area. Now, obviously, the final question, and this is for the PI lawyers that are on this particular phone call, will insurance pay out on a plaintiff's claim given that marijuana is still a federally illegal controlled substance? Just like we mentioned before with all the other contracts in state court, probably a reasonable chance that those claims are going to be enforceable. Anything in federal court, not going to happen at this point because of federal law. But that's the first question I get about products liability is, will the insurers pay on the claims? Because now that we can find these people and they're accountable and I have their unified business identifier number, I can get at them. But is there going to be any money at the end of the day? Because really the big target is the insurance company. So just food for thought. Next slide, Tom. Thanks.
Okay, so we've got a bunch of questions, and we'll start rolling through some of these. Okay, we're asked about crop insurance. Is out there? Is the crop insurable? And I'll actually combine this with another question, which was asking about delivery and transport of marijuana on state roads and whether there's insurance out there for that. And the real answer is yes, there is on both, but it depends on the underwriter. Originally, Lloyd's was the first big underwriter that got into this space. And so they laid a lot of the groundwork for what sorts of things were insured. So on the inventory side, I think you saw insurance for retail inventory, but they had not yet moved to crop insurance. And most people didn't pay for the retail inventory insurance because the type of price that they had to pay per value of the product was insane. And so I don't know many of our retail clients that actually pay for that insurance. And I think the crop side would have been the same in terms of it may be out there, but it just wasn't that valuable because the insurer knows that marijuana is a new it's a new thing that people are doing at scale. I mean, just because you're able to grow 5 plants in your basement doesn't mean you're going to be able to maintain a 30,000, 50,000 square foot grow facility. And so if you are maintaining that level of grow facility, you're going to run into some problems. And we've seen lots of crop failure. And so while crop could be insurable, I'm not sure right now that the price that you'd have to pay for crop insurance is going to actually render a bunch of people that would actually get it. Now, on delivery, transport on state roads, states actually generally regulate heavily the route that a driver can take. And so it's a really specifically insurable thing. And I think a lot of our businesses out there that are either doing just distribution or that are producers that are selling at wholesale, making their own deliveries, do get specific driver and delivery insurance. Another question was, what about what are our thoughts on alternative payment companies? And so there's a few ways that we're seeing this. We have people who are looking to do Bitcoin type transactions. With people who are out there looking to do stored payment systems, similar to at Starbucks, you can put all your money into your Starbucks app and then pay with the app at that location. And then we have other companies that are trying to basically do their own ACH type transactions where you have an account with this company and then they facilitate the ACH transaction between your bank and the marijuana business. And all of these companies are really doing the same thing. They're trying to get around some of the limitations of access to banking puts on the space. Now, though they're interesting companies, but I don't think any of them really offer the full-fledged alternative to banking that's out there. I mean, there is no there's no answer to banking other than changing federal law and making it so that banking access is more available, and making so that big banks get into the space as much as small banks do. Because at the end of the day, you still have to pay your federal taxes. Yes, you can pay those in cash, but it's difficult. You still have to pay your payroll taxes. Those you actually cannot pay in cash unless you want to risk the federal government penalizing you for it. You have to pay your employees. You have to pay your vendors. It's challenging to be involved in these alternative payment structures where, at best, you're getting alternative payments between the customer and the retailer, or maybe between the retailer and other vendors in the cannabis space. But that doesn't mean that all of these outside vendors, the federal government, etc., are going to really involve themselves in those alternative payment systems. And so you're only fighting half the battle there. Another question. We're talking a lot about federal law, but insurance is regulated at the state level. Therefore, what is the issue? It's simply this. State law does the regulating of the insurance industry. But on the criminal side, federal law is the supreme law of the land. And so the Federal Controlled Substances Act and the Federal Anti-Money Laundering Regime, those are the things that we really need to focus on, because those are the limiting factors. And I've talked a lot about Lloyd's in this space. A couple of people have mentioned, I'd be remiss to say that Hanover, a German underwriter, has sort of really taken over for Lloyd's in this space. I think a lot of their policies are pretty similar to what we're seeing from Lloyd's.
And somebody asked, and just quickly, how does all this information apply to testing companies? Because this is also an area of great development where many, many people want to run quality assurance testing for these licensees, and even in that, those licenses can also be coveted from state to state. All of this information still applies to them. They are an ancillary service provider. They are not manufacturing or cultivating marijuana. They're not even reselling it. But the fact that they take it into possession and manipulate it, analyze it, they're still in possession of it. Federal law would still apply. For insurers, when we talk about laboratory services, again, you're going to want to make sure that your lab is constantly adhering to state regulation, which changes with great frequency, and that they are subscribing to the acceptance standards for quality assurance testing mandated by the state and, frankly, agencies surrounding pharmacopoeia when they issue their journals each year about what's acceptable standards for quality assurance testing with crops similar to cannabis. If they're not doing that, you can imagine, especially in the context of products liability, if you get a faulty test result and that test result at face value is accurate, they too are liable in the chain of distribution for that analysis. So you're going to want to make sure you're working with people who are meeting state regulation and or exceeding it at all times.
Okay, good question. How are insurance agents handling coverage in states where licenses are being awarded and leases are being signed, such as Maryland? And so you generally see it in this way. Okay, so the insurance agent gets licensed in the state to offer insurance in that state. Generally, the state agency that is doing marijuana licensing will require, at the very minimum, an insurance general liability policy letter from an insurer prior to issuing a license to a cannabis business. And so the insurer or the agent drafts that policy letter that says, here's the policy that we're willing to offer you, here's the premium that you're going to have to pay, here are the sort of big ticket items on the policy. It's not the full policy itself, it's really a letter of intent. And the applicant takes that to the licensing agency, they give it the thumbs up. And then after they give sort of full thumbs up, you're ready to go get licensed to the business, that's when the business has to go back, go to the insurer, actually pay the opening premium, get the full final policy, show that again to the state, and then the license issues and they're ready to rock.
Okay, so we are at 11:03 our time, and that leads us pretty much to the conclusion of this presentation. There's our contact information. And by the way, please do read the Canna Law blog. It's our firm's blog dedicated to this particular practice area. We publish once a day, and we have covered many, 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 many of these topics that we've discussed today. And if you need more information, I suggest you go there.
Great. Thank you, Hillary. Thanks, Robert. That was a great discussion. It's obviously a complex and evolving area, one that we're going to keep an eye on. And as you said, you're keeping an eye on it, certainly in your blog, the Canna Law blog. So thank you both for that. I want to read the final CLE code. It's 1657. The final CLE code is 1657. Also, you will receive CLE information by email, so please make sure you have that code 1657 plus the one I provided earlier. You want to make sure you get credit for your participation in this. There was a lot of really active participation in this webinar with a lot of good questions, and I thought Hillary and Robert, you did a great job getting through a lot of those. So thank you for that. This is a lead-in webinar to a conference we're doing on emerging issues in insurance. We're tackling a lot of issues that are disruptive, either by technology or by policy changes. So we're covering not only this topic, but the proliferation of drones, increased use of social media in business, obviously all the cyber risk and data breach liability that's out there, foreign products liability. Dan Harris, also from Harris Moray, will be speaking there. He's got a popular blog, the China Law blog, which is widely read in that area. And we'll also discuss some constant insurance issues like allocation, additional insureds, primary and excess liability, those kinds of things too. That's going to be the Emerging in Claims Insurance Conference in Los Angeles, February 25th and 26th. If you're interested, please check out the litigationconferences.com website. So with that, again, you'll get the CLE form. Please take a minute to tell us what you thought of the event and what other kinds of topics you'd like to see us cover in this series. If you'd like more on this particular topic, let us know that, or if you have other ideas, or if you want to work with HB on a webinar or other conferences, please let us know that. So with that, this is Tom Hagee with HB Litigation Conferences. Kathleen Regan was assisting me on this as well. Thanks to Hillary and Robert, and thanks to Harris Moray for allowing you guys to join us today. We look forward to working with you on another webinar. Thanks, guys.
Thank you very much.
All right. With that, I'm going to shut down the webinar, and everybody have a good rest of your day.